Welcome to the land of 10,000 claims. Happy 4th of July. I'd like to talk a little bit about fireworks. Stay tuned.
Ow!
Thank you for joining me here today. As you can see, I'm without my co hosts, Mike and Scott, here today. I know we mentioned that our next episode would be the mining episode. We have that recorded, it's in production right now. So don't worry, it's coming. But today I wanted to talk a little bit about a fireworks case because it's the 4th of July, and I thought it'd be a fun one to talk about. So before we get into the case today, I just wanted to remind everyone that although I am an attorney and I am going to be talking about a legal topic, nothing here should be construed as legal advice. If you would like some legal advice, you're in luck because I am an attorney at Fields Law Firm. Our law firm goes over a number of different areas, including workers' compensation, which is my area of practice, but we also handle disability and other types of claims. Um, any questions, go look at our website and you can get in contact with us at fieldslaw.com. That's FIELDSLAW.com. So I'll admit, I'm a little bit of a, let's say, work comp enthusiast. I think that's the kindest way to describe my enjoyment of workers' compensation. Um, when holidays and things come up, because workers' compensation has been part of my life for so long, I get curious and I try and find out if there are any cases associated with different holidays or different occasions. And I was a little bit surprised. I did some research to look at fireworks cases and 4th of July cases, and I thought, okay, maybe I'll find a single case, maybe not. Maybe I can just find something about some type of explosive or something like that. Instead, I actually did find a couple of different cases. Now, I want to talk about one specifically today because it was the one I found most interesting. So I have read hundreds of cases in workers' compensation. The research tools that lawyers have nowadays to look up past cases is just incredible. I can look up cases that are 100 years old with very little to no effort. And I have just read so many cases. Sometimes it's been for research purposes, sometimes it's just been for fun, sometimes it's been for the podcast. And when I'm looking at a case and I'm trying to figure out if it's interesting, I'll admit most workers' compensation cases, even the routine ones, are pretty interesting to me, just because that's who I am. I'll admit it. I enjoy workers' compensation, as you can guess from the fact that this podcast exists. But I need to figure out how to classify cases to make them interesting to people that aren't in workers' compensation, that don't care about this topic in the same way I do. And I look at cases in kind of two different categories to figure out if they'll be interesting or not. And if they fall into one of these two categories, I know I'll be good. The first category is that the circumstances or something about the case is just absurd. It's so different, it's so weird. It's something you tell people and they have to hear it twice to fully understand what happened. And those are fun because they're just kind of have a little bit of the shock value, a little bit of the just oddity of it. An example of a case like that would be there was a case I've talked about many times, and I will certainly talk about it again as we get closer to Christmas. There's an old case where a mall Santa lit his beard on fire. So, Santa lighting his beard on fire, that's just not something that comes up every day. It's a very weird visual for people to think about. So a case like that is something I think most people would find interesting just because of how weird it is. The second type of case that I find interesting and I think would translate to other people finding interesting is one like we have here today, where although some of the facts of the case are pretty routine and normal and maybe something you would expect, you have a personal connection to it. So for example, when Scott, Mike, and I were recording the mining episode, which will be coming out soon, one of the issues we talked about there was dependency benefits, which would be the benefits someone gets being a dependent of a worker that actually died while working. And the three of us were talking about dependency benefits, and we were talking about them being low. And the three of us are all sitting there, and each of us has young children. And when you think about things like that, you feel a connection to it. So accidents, severe accidents happen, and there are death cases that come up in workers' compensation. But when you start talking about how it now affects the family that's remaining, you have that kind of personal connection that develops for cases like that. Now, the personal connection you have with a case doesn't necessarily have to be that extreme to make it interesting. In a case like the one for today, it's it's something more like I can just kind of identify and I understand where the worker was coming from. So the case today, it comes to us from the Supreme Court in 1930. The incident happened in 1927. So we're talking about something that happened 95 years ago. So to kind of lay the groundwork and understand the circumstances here, there was a construction site where they were building, and let me make sure I get this right. They were building a hospital for a railroad. Sounds odd to me that you would build a hospital for a railroad, but I mean, I guess if there were enough people around the railroad before, makes sense to a degree. So I just wanted to point that out. It's just a little bit odd to me. So they have this construction site. They're they've got kind of a, it sounds like they had a concrete slab down. They were starting to put floors in, so there were some different kind of elevated areas here. And on the 4th of July, the American Legion was going to put on the fireworks display. So the Legion asked, hey, could we use your location just to shoot off from? They got the okay from the construction company, and they did a full fireworks display on the night of the 4th. By all accounts, everything went out well. The next day, the employees are starting to gather for the workday. The foreman wasn't there yet. So the employees are gathering, day's about to get started, and you have the employees kind of looking around the job site. The employee that actually is injured in this case is looking around, and he's trying to see, okay, was there any damage? And then he starts picking up, or at least it's his testimony that he started picking up things, like he started picking up some of they used posts to shoot off the fireworks. So he's going around picking things up, and then he notices it sitting there, strung between a post. There's an unexploded firework. Now, this is where my personal connection to the story comes in. He sees the firework hanging there. He turns to his coworker and asks for a match. Now, I would like to think that if present day me was faced in that situation where I see a large unexploded firework, I would have the restraint not to light it off. Because there's part of me, the husband and father, that goes, my safety is important because it affects other people. I shouldn't put myself in a situation like that. There's the lawyer part of me that looks at that and goes, I could damage something, someone could get injured, there's liability issues, I should leave it alone. But then there's the last part of me that goes, I could light that fuse and get pretty far away before anything happened. And I think present day me could avoid doing that. Could I say the same thing about, 20-year-old me? I don't know. It's tough. And even if you don't have those same impulses that I do, you know someone that does. You know someone that would see that and go, yeah, yeah, I'd blow that up. so so he lights a match. Now, he talks about the case talks about him lighting the firework. And the question is really what type of firework were we talking about? Because there's a difference between a sparkler and a commercial grade firework. Now, the court finds the testimony of the employee not particularly credible and actually rules against the employee on the lower level court. And I'll get into that in just a minute. But the injured worker in this case talks about, it's like a firecracker hanging from a wire. The court in their decision notes that the fuse was 8 or 10 inches long hanging from the bomb. And they actually use the word bomb to describe the firework. So I don't know exactly what type of firework it is, but if we assume that the court is generally correct here in their analysis and the facts that they picked up, think about an 8 to 10 inch fuse and more of a bomb than firecrackers. So now to the injury itself. I'm sure all of you can imagine what happened here, but let's talk about the specifics of it. So the coworker who, I mean, work comp is a no-fault system. There's no one to blame when there's a work injury. The system is just there to kind of deal with the aftermath. But his coworker gave him a match. Like, you can't, like I said, no fault system. You don't put blame on anyone, but this coworker just gave him the match and basically told him to go for it. So, I mean, I would put some of the blame on him, but once again, no fault system, so it doesn't matter who's to blame. So he lights the firework, and rather than it kind of, delaying going off because it has to go up the 8 to 10 inch fuse, apparently it basically explodes instantly, and the employee ends up losing his left hand. Which, honestly, in reading the description of the fuse, I thought it was going to be more severe than that. I thought it was going to be potentially fatal when I started reading this case. But luckily, it was, losing your left hand is terrible, but, it certainly could have been worse. So that's the incident that happened. And now let's talk about the workers' compensation side of it. He takes it to the lower court, and his benefits are denied at that level. The Supreme Court is now reviewing the decision of the lower court. For those of you that don't practice law or aren't familiar with it, when a lower court makes a determination, the courts of appeals above it are generally going to leave the facts that court found alone. The reason is because the courts of appeals, either the Work Comp Court of Appeals, which didn't exist at this time, and the Supreme Court, look at a case that has come up to them and will say that, we were not the ones there listening to the testimony, so we can't decide if someone was credible or not. So if you found the facts to be this way, Judge, we're going to go with you on it. And most of the time, they're just going to review the legal side of it. They're not going to go after and try and change any of the underlying facts. So the default is this: the courts of appeals want to leave decisions alone unless they're given a legal reason as to changing it. So they look at this case and they see that the judge on the lower level determined that the employee wasn't a particularly credible witness. They didn't believe him because the employee was trying to say, look, I got to the job site. I was trying to clean up a bit because things were a mess. I found this firework. There could be kids around, so there's kind of a safety issue going on. We weren't going to be able to do our work with a firework just hanging there because who knows what could happen with it. So I had to dispose of it in some way. That's not an unreasonable thing, I think. I think most cases where you have circumstances like this where it's a safety issue and someone in good faith tries to do the best thing, I think the outcome's going to be different most of the time. But in this case, the judge found that that was not credible. He didn't believe that that was happening. What the judge in this case basically said on the lower level was that, um, you weren't really starting work yet. You hadn't entered what's called the course and scope of your employment. And, exploding bombs was not in line at all with the work that you do. So I'm going to say you weren't in the course and scope of employment, therefore, no benefits. Now, the phrase course and scope of employment, I want to, for people that aren't familiar with workers' compensation, I kind of want to explain a little bit about what that is. So, for work injuries, the two parts to a work injury are it arises out of your employment and it's in the course and scope of your employment. Arises out of means that work puts you at some special risk or hazard, or there's some connection with work that kind of helped the injury occur. So in this case, obviously there was a firework on a job site. And then the next part is in the course and scope of work. Course and scope of work, I think the easiest way to think about it would be there's a group of job duties and responsibilities that you have. And if you're injured doing one of those during work time, um, that's going to be well within the course and scope. And it seems pretty straightforward, but it gets very tricky when you start having employees with different job duties. So, for example, traveling employees, it's very difficult to say exactly what their course and scope is because if they're going from one job site to another, they're generally going to be covered for almost all activities they do, even if it's not necessarily work related. And then you get into different doctrines such as personal comfort and things like that. So just know if you have issues or you have a personal case in your life where there's question on if you were actually doing work or not, it's going to be a very fact specific finding, and it gets very tricky, which is why I'd recommend talking to an attorney if you have questions about things like that. So in this case, the court says, we basically find that the judge was probably correct, and we don't want to mess with his decision. And they go ahead and affirm the decision. So that means they agreed with the lower judge, and the employee in this case did not get benefits. Now, I know some of you are listening to this and thinking, okay, well, obviously he didn't get benefits. He blew up a firework at work and blew off his hand. But I think the call was a lot closer than most people would think, especially workers' compensation being a no fault system. I think if you change or add a couple of facts to this, I think then suddenly it absolutely will go the other way. So, for example, let's say, that it was normal for this employee to do some work before the foreman showed up, and cleaning up the job site or organizing things was part of that job. I think the court then might look at this case differently. Or let's say that he had more of a reasonable concern that kids could get in and mess with the firework if he didn't do something about it. So there was a greater danger and a greater safety issue. I think it certainly could go the other way. What most people don't understand is that in workers' compensation, because it's no fault, just because someone does something that may be unwise, that doesn't mean it's not going to be a covered work injury. So that's the takeaway for today is that you shouldn't play with explosives, especially if they're unknown, have an 8 to 10 inch fuse, and you don't know how to control them. But you should also know that even though in this case this employee was not awarded benefits, that just because someone does something maybe not necessarily consistent with their job duties, maybe not the most wise decision, that they still can be entitled to benefits. And if you're in a situation where you've been denied, you should probably reach out to an attorney and figure out if it could certainly go the other way, because in a case like this, it could have easily gone the other way. I think there are some facts that could have easily turned this case. So, everyone out there, be safe. Have a great 4th of July. Be careful with any fireworks or explosives. And we'll be back next time, and we're going to be talking about mining in that next case. And Going to be talking about a lot of pretty difficult subject matter in that one. So stay tuned, and thank you for joining me today here in the Land of 10,000 Claims. Thanks.